So beside me, I have someone that you probably all know from New York, Edna Sussman. She is an arbitrator and mediator and the distinguished ADR practitioner in residence at Fordham Law School. She was formerly a partner at White & Case and then the firm Hogarth, Newman, Regal, and Kenny. She has vast experience in complex international and domestic arbitrations and mediations. She's been appointed arbitrator more than 300 times and is ranked Band 1 by Chambers Global for international arbitration. Edna is practically on every arbitral roster, including the AAA, ICDRA, CPR, SIAC, ICC. And she also has an interest in psychology and cognitive processes and has written many articles, in particular about bias and unconscious drivers in decision-making. Beside Edna, we have José Astigarraga from Miami. He is a fluent speaker in English and Spanish, and his arbitral practice is conducted in both of these languages. He is a partner at Reed Smith LLP in Miami, and he's currently transitioning to a mediation and arbitration practice. He's a very experienced advocate, mediator, and arbitrator. He practiced in the firm's international arbitration practice. He has experience in construction, energy, investment, and business disputes. He was the global chair of international arbitration at Reed Smith. He was also the vice chair of the London Court of International Arbitration. He co-chaired the ICC Task Force on Witness Memory and Evidence. And his recent speech in Flaws on Human Reasoning and Technology was a finalist for the Global Arbitration's Best Speech of the Year. And he's ranked as Chamber Band 1 for international arbitrations in the US and in Latin America. And beside Jose, we have from Canada, Professor Timothy Moore. He's a professor at the Department of Psychology at York University. His expertise is in memory and evidence and of witnesses in criminal proceedings. He's testified as an expert and written academic articles about the fallibility of memory, how it can be distorted, eyewitness evidence, false confessions, and the search for truth in legal proceedings. All three of them have websites, and those websites list in more detail their CVs and their publications. So thank you. Today we're going to talk about unconscious drivers and biases and blind spots that affect our decision making. And we're going to start with Edna. As arbitrators, we're required to be independent and impartial, and our goal is to generate an award based on a reasonable view of what happened with the correct application of the law to the facts. There's been a lot of discussion about unconscious influence on decision making and biases that affect decision making. Edna, I'm wondering if you could talk about what you think are the top 3 blind spots or biases.
Great, thank you. So 15 years ago, I went to a meeting at the American Bar Association, and there was a presentation on work that had been done on blinders, biases by judges. And I thought, oh my gosh, if it's a problem for them, it must be a problem for us too. And so I kind of embarked on the study that I have done really of unconscious bias. So what is it? It really means, I don't know how many of you read David Kahneman's book, Thinking Fast and Slow. I'm sure many of you have. Right, so you all know about the thinking part of the brain, and the part of the brain is just intuitive, automatic. You really have no control over it, which is what drives this. So why are we still talking about this? Because we did talk about it a lot 12, 11 years ago, but it is a perpetual problem. Like we talk about disclosure perpetually, we talk about efficiency and cost perpetually. It really was time to revisit this and bring this back to the fore, because our minds are really not working any differently than they did 11 years ago when we first started talking about this in this space. So we thought a reminder now, and taking it to perhaps a new level in terms of some of the aspects that we had not focused on as much, which you heard a reference to. You heard a reference in that last session, actually, to the cultural differences as they may impact on costs. And culture is not something that's been discussed as much, which we will touch on today. But my immediate job here is to talk about the biases, the blinders. The use of the word blinders was the one that had been developed by the people who did the judge study, because biases was such a loaded term. So they called it blinders instead, but it's the same thing. It's that part of your brain that doesn't really analyze the facts as thoughtfully as you kind of hope you are doing in all cases. So there's an informational bias. Privileged documents is an example of that. I'll give you an example of a study about that. Other kinds of informational biases could be prior bad acts. I mean, how often do counsel try to tell you about how they did this other really horrible thing, which is totally irrelevant to the case, but they try to introduce it because it might impact you and probably will impact you subliminally, even if you exclude it, or subsequent remedial measures when people have fixed a problem later. That really shouldn't be relevant to whether they should have fixed it before. So that's another example of an informational bias, informational blinder. Cognitive biases is what we hear about a lot. That's sort of the automatic part of the brain. It's just doing its thing without any control by you, by the thinking part of your brain. Anchoring will go into a little bit, confirmation bias a little bit, and hindsight bias, all of which, we said, let's pick the three of those that are most important, most relevant to what we do as arbitrators, because there are an infinite number of biases and blinders that the psychologists have come up with. We thought those three really were the ones that were most germane to our discussion. And attitudinal, personal predilections, culture, that kind of thing, which we haven't really spoken as much about in prior years. So turning to some of the studies. No, yes. So privileged communication. So there was a privileged communication. Half of the judges addressed the claim of attorney-client privilege. It was a very, very devastating document. So just 75% of the judges said it was privileged and it was not admissible, it should not count towards their thinking. Half of the judges did not see it. So was there a difference in the outcome? The judges who did not see the document, 55% found for the plaintiff, and the judges who saw it and ruled that it was privileged, 29% found for the plaintiff. So that privileged communication, which they saw, which they excluded, had a very, very dramatic impact on what they ultimately found. Cognitive blinder anchoring. You hear a lot about anchoring, right? And it's very germane. The claimant comes in with a number in the stratosphere. So it's not a very good number. But does it anchor you to a high number? I don't know. Let's see. So there was an auto accident. Same facts were presented to both sets of judges. Some heard a demand of $10 million in the settlement conference. The other one heard a demand for a lot of money. So the judges who heard the $10 million came up with $2.2 million. The judges who heard just a big number came up with $800,000. So think about what happens when you see those numbers and how they impact your thinking. And maybe the respondent really ought to come up with a number as well and not just rest on criticizing the expert on the other side, because maybe you need another anchor to change that anchor. So at least there are two anchors competing with each other, and then maybe they'll look at the underlying facts and not be as influenced. Something to think about. Cognitive blindness. So this is a study that was done a long time ago, but take this forward to today. And I mentioned this one because this is the only one I could find where they actually, hook people up to little machines so they could see their brain and what was happening. So this was the Bush-Kerry election, and things that were good about Bush was all that the people who favored Bush could hear. The other stuff just got totally filtered out. It didn't even get to the thinking part of the brain. Same with the Kerry people. So what do you think is happening today in the US of A and many other countries? Are we hearing each other at all? I don't think so. But it's not even that they're not listening on purpose. It just doesn't even get to the thinking part of their brain. So that's why, 75% of the Republicans think the 2020 election was stolen, right? But they don't hear the other facts. It just gets totally filtered out. So we have a very, very serious political confirmation bias problem going on in the US, and I suspect in many other countries as well. All right, I guess just to go back for a second. So, what does it have to do with us? And, the example that I see as most relevant is preliminary views. The studies have shown that a fair number of arbitrators will form a preliminary view. They're open-minded, they are, preliminary view before the hearing, after they've read the submissions, the pre-hearing submissions. But what are they really going to hear after they form the preliminary view as the hearing progresses? Are they really only going to hear what confirms their initial analysis of the case? Or are they really going to be as open-minded as they think they are and be receptive to really reassessing everything? But I think the prime example of that is, the Germans do have, as their courts do, they do often even share their preliminary views with counsel. And I had, back when this was a popular subject 13 years ago, I gave this talk a lot of times. And so on 2 occasions, a German arbitrator got up from the audience and said, oh, that's not true. There's no confirmation bias when we give preliminary reviews, because I changed my mind once. And I rather thought that proved my point. So, be careful, because confirmation bias is a real thing. Okay, hindsight bias. Again, something that's relevant to what we do, because so much of what we do is to go back in time. So with the failure to take precautions against flooding negligent, if fine yes, if at the time you would have found more than 10% likelihood of a flood. Half the judges were told no precautions were taken and there was in fact a flood that cost, in this case, $1 million. So, did it make a difference? Obviously, whatever happened later is not relevant. The fact that there was a flood is no demonstration of whether they were negligent at the time. You have to look at the fact at the time to make that determination. So, those who were not told about the flood, 24% found negligence. The ones who were told about the flood, 57% found negligence. And Jose and I both said the best example we have of this really is Madoff. I mean, we know what happened. And I guess the way it really came up in my case, we were struggling with how much discovery, how many document disclosure they should get after the seminal event when they collapsed. Because the more we went forward in time and giving them documents that would, in a sense, create this confirmation bias, they should have known, look, all this stuff was. And so we actually gave them a pretty limited period of time, really, I think, to try to avoid as much confirmation bias as we would have had we taken it forward. All right, so I guess that is, so just this one, and this will be picked up on again later, but it's in my slides down. But the idea of how difficult it is to overcome and reverse and deal with this, because people don't believe that they have this problem. We're all really thinking very carefully about our cases. We are definitely analyzing all the facts as they come in and listening to the arguments. But there is such a thing as egocentric bias. And we think we're doing a great job. And this was actually Susan Frank's work at that conference. And so, I'm wearing the wrong glasses. 85% of the responding arbitrators thought they were better than the median arbitrator at the conference, making accurate and impartial decisions. So we are really sure about ourselves, aren't we? And 92% of them thought they were better than the median at doing efficient proceeding and resolving the disputes. So, that kind of certainty really kind of counters and works against really taking the kind of time to overcome your biases. And there's a whole thing about, things kind of, you feel really good when you come to a decision, so the egocentricity is not an odd thing. It's like, this brain, the dopamine kicks in. I got it, I figured this out. I have figured out this problem, right? And so it really feeds into this and makes it much more difficult to reassess and go back and think, did I really look at everything appropriately to counter these and the many other biases that the psychologists have pointed out. So that's an introduction to the subject, and I'm going to turn it over.
Jose, I'm hoping that you can give us a couple of real-life examples of cognitive bias or blind spots that you're aware of.
Gladly. Before I do that, though, I wanted to pick up on, really think right off what Edna has just said, talked about Susan Frank's study on overconfidence and so on. Edna and I have been speaking about this subject for a long time, really proselytizing about the importance of cognitive bias and mental flaws in meting out arbitral justice. And one of the things that I have found, I know Edna feels the same way, is that it has been a challenge to persuade lawyers in particular on the importance of this issue and the pervasiveness of this issue. And in part it builds on the fact that we're dealing with confirmation bias, right? So basically we were faced with, whenever we've given this talk, the people say, wow, that is really interesting. On the other hand, they also say, and they told me, Jose, that's really great, but that's really, these are my words, really unwashed masses. We're very educated, we're very smart, and we know that, we're not as vulnerable for these sort of things. And we just wanted to drive home, if I may, the 2 points, which is the very deep importance of confirmation, cognitive biases which go beyond arbitral justice, but they're central to arbitral justice. And the second point is the question of pervasiveness. And if I may, let's see, actually, I'm going to go back, otherwise you'll read the slide. Let me tell you the story. We all know that the United States invaded Iraq believing that there were weapons of mass destruction, right? And in fact, the invasion went on, and the United States discovered that there were not weapons of mass destruction. And the U.S. did a post-mortem analyzing, okay, what went wrong? And I'm quoting from the report that was rendered by the commission that did that post-mortem on the intelligence failure. And here's a page in which they essentially said, confirmation bias was at work. In some instances, analyst presumptions were so firm that they simply disregarded evidence that did not support their hypothesis. When confronted with evidence that indicated that Iraq did not have weapons of mass destruction, analysts tended to discount that information. Rather than weighing the evidence, they accepted the information that fit the prevailing theory and rejected information that contradicted it. The analyst's frame of reference was so strong that contradictory evidence was discounted. It's a long report, but the gist of it is, these were people acting in good faith. They were smart intelligence analysts, but they were so, their views had formed so strongly that they were unable to pick up. Essentially, we had this intelligence failure, and my point is people died, right? So my point about confirmation bias is cognitive bias. This is serious stuff. The second thing that struck me as I began looking into this is almost the fickleness of the justice system, and in particular, the decision-making process, right? And so we all know that and I'll tell you about a study that was done in the Israeli justice system. And we all know that prisoners, when they go to prison, can have their sentences reduced for good behavior. It's called parole, right? And they can petition and say, I've been good, would you please let me out early? And so there was a study done in the Israeli justice system of thousands of petitions for parole that were by prisoners. And essentially what they found is that the results of when the petitions were being granted varied, right? And so here's a chart, and the higher you go in the chart, it means more favorable petitions. The lower the decisions go, means unfavorable decisions, right? What I haven't told you is that the horizontal axis is the course of a day, and the high points coincided with breakfast, a mid-morning snack, and lunch. And here is the slide of the researchers. What the researchers found, and they speak like researchers, but what they said, our findings support the view that the low is indeterminate, and this is so uncertain, by showing that legally irrelevant situational determinants, in this case merely taking a food break, may lead a judge to rule differently in cases with similar legal characteristics. Notice, think about if you heaven forbid, that you or someone near to you wound up for some reason being in prison. Think about the result or the injustice you would feel because you happen to have gotten the late morning slot. And so really, this is an example in the prison justice system, but the reality is that we have this within arbitration itself as well. And part of my message has been, wrapping up here, is that when I've spoken on these things, is that, I've had clients that do their processes according to Six Sigma. What that means is that they accept only 3.4 million defects per million outputs, right? In arbitration, we are not measuring the quality of our output, nor are we taking steps like other professions, for example, exaggerating, we're not taking steps. I understand, I'm saying in general, we are not paying the same degree of attention to improving our process that I submit to you other professions such as medicine are doing. And period. So that's been part of the message that I'm going to share with you. Now you've asked me about some specific instances of confirmation bias because again, it can be very theoretical, right? I'll just tell you real quick. I had one case in which my client was involved in an arbitration. I was not counsel in the case. It was being handled by another firm. Arbitration was not going well. The counsel, is that me?
That was me.
Okay, I'm sorry. It was not going well. My client said, Jose, I'd like you to come into the case because I'm worried about it. And indeed I came in, and what I discovered essentially is that the chair of the tribunal had just an incurable case of confirmation bias. There was, very simply, by that point in the case, he was seeing everything through that filter, and there was very little we could do to try to get him to see sort of the other side of the facts. And period, full stop. There were reasons, we talk about cultural or whatever, that accounted for that. The second one that I would share with you is in terms of hindsight bias. Edna has talked about the Madoff cases, in which, of course, you're looking at the red flags after the loss has occurred. I have dealt with hindsight bias, for example, in the context of construction. I represented a consortium of construction companies that were building a tunnel. During the course of the construction, there were problems with the soil. The engineers looked at it. They said, look, here's how we think we can fix it and deal with it. They took steps. They completed the tunnel. Years later, the tunnel collapses. They get sued for negligence. You should have known, and so on. And in that instance, you have the situation where, as Edna told you and showed you in that slide, the knowledge of the fact that the flood has occurred, knowledge of the fact that the tunnel has collapsed, is going to color the judgment of those arbitrators when they are trying to put themselves back in the position of those poor engineers that didn't have the benefit of knowing what was going to happen. And you're trying to judge their conduct with your brain, in effect, already affected by this knowledge. Full stop. And the final one, we talk about anchoring, and we think of it as numbers. Anchoring is not just about numbers. Edna was telling me a case where she was talking at one time to a civil law arbitrator who was sitting in a common law case controlled by common law. And these arbitrators said, well, whenever I'm looking at this case, at a case involving common law, I always look at it under my system, civil law, figure out where I would come out, and then I will look at it under the common law. Think about the anchoring effect. And again, all of the folks that I'm talking about are acting in good faith, and Tim has made a very good point. All this stuff is happening subconsciously, right? And that's the real danger. And so the point was, this arbitrator is now looking at a common law problem through the starting out with, well, this is what would happen under my system. Think about how that anchors and how for this arbitrator to move away from that, you've got, in effect, this brake pulling back. So, Robin?
Okay, now I'm going to move over to Tim. We've discussed flaws in decision-making, Tim, but there's other people involved, including witnesses. And I thought, given your expertise on memory and witnesses, you could discuss some things for us to think about memory.
Not my water. Not only that, I forgot the question. No, just kidding. Are there threats to witnesses' reliability? Well, let me count the ways. Memory science is relevant to any situation in which a person's recollections are going to be used as evidence of some former event. But, and this is a big but, memory isn't like other kinds of evidence. If you think about bullets, shell casings, blood stains, hair, clothing, fingerprints, they can all be found in the evidence room, and they won't change over time, at least not much. You can retest properly stored blood samples repeatedly without changing the features of the sample. But the same isn't true for memory. Whoops, this is falling apart. Or is it? Maybe it'll work in a bit. Yeah. There's an intangibility to memory. I can't say, hey, Robin, come over here and take a look at this memory. Memories don't sit on the shelf in the evidence room They exist in the witnesses' heads, and their accuracy will depend upon a whole bunch of factors. How thoroughly were the original perceptions encoded in the first place? How much time has passed? How were the memories elicited from the witness by investigators or by lawyers? When investigators try to get information from a witness, we don't want them to do it in such a way that it contaminates the information. We don't want to mess up the memory by making mistakes that can alter that memory, possibly permanently. Our memories are routinely fallible. Most of our day-to-day activities are not well remembered, if at all. I need to remember where I parked the car, but only long enough to retrieve it at the end of the day. Normally, it would have been under Nathan Phillips Square, but I took an Uber today, thus relieving me of a memory problem. Anyway, we remember enough to be able to function efficiently, but our brains are not the repositories of the video stream of life. And I'm not suggesting that our memories are arbitrary or capricious. Not at all. On the contrary, we're really good at recalling what's important. But forgetting is adaptive. Otherwise, our heads would be full of irrelevant, obsolete, useless information. That would be hugely inefficient. Show research participants a video clip of a car accident and then ask them to estimate how fast the cars were going when they collided or crashed. You get faster speed estimates if the question is phrased with the word crashed than if the word collided was used. And in another study, did you see the broken headlight versus did you see a broken headlight? Depending on whether you use a definite versus an indefinite article, you get greater false reports of the presence of a broken headlight. And there was no broken headlight. With some fairly minor suggestions and contrivances, it's not that hard to get some people to falsely remember shaking hands with Bugs Bunny at Disneyland. Never happened. Bugs Bunny is a Warner Brothers character who would never be at Disneyland. Never. But it's not implausible. If you've ever been to Disneyland, you might have seen Mickey Mouse. He's there. He's conspicuous. He hangs around the front entrance. He shakes hands a lot. Maybe with you. When you're remembering that encounter years later, could it have been Bugs? Maybe. It's not hard to imagine. And it's easy to mistake the imagined event for an actual memory. The car crash study, and there's several car crash studies. Tell me what you saw is a much better question than did you see the broken headlight? Because the broken headlight was introduced by the interviewer. Now the image of a broken headlight is in the witness's head, and the interviewer put it there. So these are all examples of misinformation effects. The longer the interval between the to-be-remembered event and the attempt to recall it, the more opportunities there will be for memory alteration. And these effects occur unconsciously. So not only is the person who's doing the remembering unaware of the changes, the person who's producing the changes is also unaware. So from their perspective, they were just having a conversation. So the now contaminated memory is, for the person who's reporting it, their subjective truth. So worrying about deliberate deception is probably moot. So the takeaway message is this: mistaken memories can be confidently held and unwittingly cultivated.
So my next question is for José. José, as I mentioned, co-chaired the ICC task force on witness memory and evidence, which resulted on the ICC report on the accuracy of fact witness memory in international arbitration. Can you give us an overview of what you learned?
Gladly, it really picks up on Tim's points about memory. Again, the whole idea is as we're in arbitration, we want to make sure that the awards that are being rendered are being based on the facts as best as we can establish them with an objective application of the law, right? Well, part of establishing the facts is that we need to understand the mental processes of witness and how accurately they are conveying information to the arbitrators. So the ICC, being mindful of these issues that are taking place with respect to memory and cognitive biases and so on, in effect, convened a task force to look at the effect of memory on the value of witness evidence. Part of the challenge was, again, the issue of sort of the skepticism that exists in our bar with respect to the true existence and merit of these notions that somehow the reasoning process, the mental processes of humans are flawed in the sense that we've discussed. So the first thing that the task force did was we looked at the scientific research that was out there, taking on many of the studies that Edna and Tim have cited. And so I recommend the report to you. There's a whole chapter talking about that scientific research. The second thing we had is that a lot of these studies have to do with what they call flash memories, which is you're in the context of criminal law, right? So there's a holdup. Somebody shoots somebody, boom, bam, that's the memory. And then you're applying some of these lessons to those in that context. But in arbitration, we know that very often the controversies develop over time and memories have to cover a longer period of time with more time for reinforcement, which may be a good thing, and so on. And so some of the task force members had the legitimate question of saying, well, does this really apply to international arbitration? So we actually asked, were able to count, fortunately, on a leading psychologist there, Professor Kim Wade, who has done studies in this, and we undertook field studies in this respect. The hypothetical was done with hundreds of people, and the hypothetical was that it involved a dispute between a printing company that had heavy machinery and a company that was providing the flooring for its factory. And please read it, I think it's worthwhile. But one of the issues was whether or not the flooring company saw that these heavy machines were being moved while they were trying to assess or bid the project. If they had, then they should have known that the floor had to risk, needed to have dynamic pressure, blah, blah, blah. If they didn't, then it would be a different result, right? And so we, in effect, did two things, and we asked different folks in the study to, in effect, look at or assume that they were representing not representing, but speaking for one side or the other, the printing company or the flooring company. And in effect, one of the things that we found is that practices common in international arbitration are, in fact, impacting, can distort the memory. And so when we did this, and we remember one of the issues is called biased storytelling, which is you're telling the story from one particular perspective, and does that influence your memory? And what we found, for example, is that 66% of the participants who were asked to be the managing director of the flooring company, the one that installed it, said that the machinery was not observed, could not be observed while they were bidding the project. That was 66%. Now, there's something called post-event information, which is that someone's memory can be affected by something they learn after the fact, and in effect, farther down the road, they don't necessarily remember whether that was the original memory or that was something that in effect affected their memory after the fact. It contaminates and it all becomes blurred, right? And so in this case, in order to test post-event information, we gave them a memorandum from the in-house counsel, in the case of the printing company, that in effect led them to believe, to understand that, oh, no, the machines could not be seen when they were being moved. It could not be seen being moved when they were bidding the project. And the number increased to 78%. So we had 66%. They were told, what do you remember? No, we could not move them. Once they got this memo that contaminated the memories, it increased to 78%. But now let's switch to the other side. And the managing director of the printing company, the one that was saying, you gave me the wrong floor, only 43% of them said, no, you couldn't see the machines moving. In other words, 57% said, in contrast to 66% of the floor companies said you couldn't see it, 57% said, yes, you could see it. And when you gave them a post-event information memorandum from the in-house lawyer saying that you could see the machines being moved, only 29% of the participants said the machines could not be moved. In other words, you see the influence of the memorandum from the council. Now,